Good afternoon. We'd like to welcome all of the attendees to the Quantum Business Laws Consortium on Litigation. We noticed that people are starting to come in and it's 1 o'clock. So out of respect for everyone's time, we will begin the program. And as people enter, we will continue with the theme and hopefully it will make sense and be of good value to everyone. One of the issues that we often receive calls about is issues involving tax dispute litigation. Recently, in light of COVID-19, there's been increasing requests for information about litigation of various different sorts. So the Quantum Tax Law Consortium has expanded its practice area to include civil litigation of various different sorts. And to that end, we are pleased to bring this program to you. We have noticed from the enrollment list that there are many accountants and lawyers and business owners, executives, and public companies that have attended before, and we genuinely appreciate your support. The COVID-19 pandemic has presented many challenges, both of an economic substance and also risks of other natures, which all of us are struggling to understand how to navigate. Lawsuits in greater number than ever are starting to come about in every different sector across Canada. As the national deficit has been growing in unbelievable proportions, expected to well exceed $250 billion, we can rest assured that the CRA will be seeking to enforce collection and audit in situations where they may not necessarily have done so before. In fact, one of the concerns from a tax point of view is that companies who may be abusing or misusing legislation in order to avoid taxes may be targeted under the general anti-avoidance rules, also known as Carr. From a litigation standpoint, we're seeing situations across Canada where companies are incapable of delivering on commitments and honoring agreements, which are having financial ramifications on companies they're dealing with. We are seeing situations where employees are dismissed or fired without notice and without cause on account of COVID-19. Indeed, these are unprecedented times, times that are perilous, a period in which we're all trying to understand how best to navigate. So if you're an accountant or a lawyer or a business owner, executive in a public company, the information today will hopefully be of a high value in order to help you advise your clients or undertake necessary measures to ensure against the negative impact of litigation on your company or on your clients' companies. In a moment, we're going to be introducing an expert panel of some of the finest tax and civil litigators in Canada, as well as financial experts. In addition, we would also like to talk about how some of these individuals are able to add value through the Quantum Business Law Consortium and some of the new initiatives that the Business Law Consortium is offering for the benefit of all in attendance. I'd first like to call upon Michael Meller. Michael, would you please introduce yourself to the audience? You'll have to unmute yourself, Michael. Well, Michael's working on unmuting himself. Oh, here we are. Yeah.
I was doing sign language, but we missed it. I'm the newest partner to the Quantum team. I'm a civil litigator and have been so for over 40 years. Some people say well over 40 years. It's an interesting life to lead, being in court, helping companies and individuals and entrepreneurs to get through the issues that they're facing. It's not a good time to be an insurance company. It's not a good time to own long-term care homes, cruise lines, airlines, service providers. are all being sued, and it's just going to multiply as the days go on. Most of the insurance companies are denying their coverage. They say they don't cover pandemics. They cover physical things like floods and fires, but this is not a physical thing they claim, and so therefore their insurance is excluded. In Canada, long-term care homes are at risk of significant lawsuits. One class action for $50 million has been issued against one long-term care home, and other long-term care homes are being sued just for their treatment and care. I mentioned to Todd this morning that I heard yesterday that a report was released this week that just said that the long-term care homes are now in worse conditions than they were prior to the pandemic. So it's only going to get worse for them. With no insurance coverage, many businesses will not be sustainable. So there are all the issues about what happens when a business closes or goes bankrupt. Litigators are involved. It becomes a serious thing for the employees who've been let off or furloughed or just have not yet come back to work. Restaurants are being denied business interruption insurance, and they're fighting it like crazy. They've come up with a bit of a unique approach to cruise lines. They're being sued for negligence. Nothing to do with, in theory, the COVID-19. It's just that they were negligent. And negligence is a big area, and it's going to be something that has to come out over time. Interestingly enough, in the US, not yet in Canada, Costco and Amazon are being charged with price gouging. So they're being sued on many different lines, but price gouging is somewhat of a surprise. Depending on what airline you booked on, and Eric Kay can talk about this personally, if you've paid for your ticket, you're not getting your money back. They'll give you a credit, maybe do something for you, but if you've paid for expensive airlines tickets, you just don't get your money back. You get vouchers. Another interesting area of litigation is students in private schools, colleges, universities. They now want a rebate for the fees they've paid because they didn't get a full year's study. So those are usually one-offs. There'll be class actions for those for sure. And once you are sued, if you are sued, the defendant, that's you, will have to prove to the court that you acted reasonably in the circumstances. And that will be defined by the courts as we go along. It'll be streamlined, but it has to be reasonable in the circumstances. And that hurdle must be jumped over before you can put your defense in. But in opposing that reasonable standard, it doesn't mean you have to be perfect, because not many of us are, and certainly most of the companies are not perfect. In theory, everyone's doing their best. So it'll be interesting to see how that turns out. They will argue that not all infections of COVID could be prevented. It's an interesting argument. I don't know how you could prevent it from being in your large corporation or otherwise if someone comes in and has the virus and spreads it. So all these things will be looked at. You'll also have to plead that you were in compliance with the applicable government standards. But there's a problem with that, because that position relies on the defendant actually being able to prove they were compliant. So if there are government standards and you didn't live up to it, you're going to have to deal with that. And it relies on the government standards do not necessarily mean compliance with negligence standards. So negligence and government standards are often different. Turning a page noisily, I'm sorry. And you have to question whether the government standards were deficient. they can't be deficient in every example, so that's something that will be looked at. Yes, insurance companies will rely on force majeure, and force majeure is basically an act of God, and one of those problems would be to prove that God caused the pandemic, and I think that's an interesting twist. There'll be tremendous pressure also on the government to make some corporations and industries not be liable for non-compliance. This happened years ago in the States. The question is, will all the government buckle under the pressure to protect certain industries? That, Todd, is sort of where I see where we're going to now. I wonder, Eric, did you get your money back from your plane tickets?
WestJet has caved into pressure and is going to be issuing refunds. They started with people who bought tickets from them directly and now have extended it to people who bought through travel agents. But I've been told that it will take at least 3 months to see any money. So I'm not going to hold my breath in the meantime.
Todd, back to you.
Thank you. Thank you very much, both of you, Michael and Eric. One of the considerations that I think one would be wise to consider in the context of a force majeure clause or the absence of one is whether or not closure of a business facility, such as a manufacturing plant, by comparison, who generally hasn't been closed, compared to, say, a retail store, whether or not the company had a choice of closing. They were mandated by the government in order to close. How would that affect the difference in the way that the courts would look at failure to deliver or to honor the terms of an agreement? If a company was forced to close, mandated by the government, versus companies that had employment issues, such as staffing problems or people afraid to come to work and therefore unable to deliver. So I would present that question first to Michael and then to Eric, please.
Well, sorry. It will be heavily litigated for sure. I think it would have to be that it was reasonable that the government shut you down. And so if you have a practice that has essential workers classified and you're open for business, that's affected the business of companies that are not essential. And so it'll have to be a reasonable determination in each circumstance. So there was not one clear answer.
Eric, what is your view of the difference in the way the courts may view a situation where a company was mandated to close versus one had closed as a result of, in their view, no fault of their own on account of COVID-19?
Well, I think what the court is going to look at is whether the contract is being temporarily frustrated or completely frustrated. And it will be interesting to see what the court's take is on that, where you've got a situation where somebody is only being delayed in performance versus not being able to perform at all, how they're going to look at that. The same as it'll be interesting to see how the courts look at the effect of the pandemic on reemployment, where when somebody's being terminated, and whether they're going to increase notice periods. Some industries may actually have legislation that deals with that. For example, I think under the new Construction Lien Act, there may be some provisions in there that deal with delays in performance and how they're allocated. But my view is that overall the courts are going to be quite sympathetic to people who couldn't perform through no fault of their own. So if you're mandated to close, I don't think that unless there's more to it than that, that a company is going to be allowed to terminate a contract due to non-performance where there's a mandated temporary closure.
Very good. I would like to call on David Yanigu to comment on a business continuation issue where there may be a situation where the courts may be inclined to make an order against the company that arguably was not mandated to close, but for reasons in their view beyond their control, but not be in the view of the court. So as an example, supposing that we have a manufacturing plant that couldn't obtain materials and later was forced to, in their view, to shut down their plant. David, I'd like you to comment in light of a decline in the economy, the way that a business valuator would approach this and what the view would be. David, please.
Sure. So if one was to look at remedies for breach of contract, one of them is the accounting of profits. One of the remedies available to a complainant is an accounting of profits. So the courts would typically look at what the loss quantification would be, but for a breach of contract, should that be deemed the case. So should the court deem that the contract was indeed breached. Now, the valuator who's doing the loss quantification will also look at the macro environment of that business. So if that business would have encountered a negative or a decline in business due to COVID, well, then they would not be profiting for that in the loss quantification. So the loss quantification would be reduced for the COVID impact, if you will, in that accounting of profits.
And is there a general percentage of adjustment that would be made in, say, in a typical manufacturing company on account of COVID-19? And I'm not thinking of medical companies or other companies that are doing better like food, but I'm thinking of companies that would have been affected. Is there a percentage of reduction that one would make when you look at EBITDA and other issues with respect to multiplications of profits that companies would normally be looking at in order to substantiate a value from a business valuator's point of view?
There isn't, and because the situations are so desperate, there's too many factors that go into that level of quantification. So there's nothing that I can share with the group right now, but definitely it's a factor.
Excellent, excellent. Next, I'd like to call on Brian Carr. Brian, I would like for you, first of all, to introduce yourself to the audience, and we'll engage in some discussions on tax litigation, on how we can navigate a tax dispute. Brian, we're eager to hear from you. First, perhaps you could introduce yourself. Following that, we can have some discussion on some of the strategic methods of resolving issues, both with the CRA and the Department of Justice. Brian, if you please introduce yourself.
Okay, I'm currently a counsel at Thorsteinssons. I've been there for about 3.5 years. I started my career off as an articling student back in 1973 with what was then Davies, Ward & Beck. And I was there for 25 years. Then I joined what is now Denton's and was there for about 10 years. Then I went to KPMG Law for another 8 years before landing finally at Thorsteinssons. During that period of time, I guess up until about 10 years ago, my practice was generally about 3/4 planning with some tax litigation. I really liked doing the tax litigation because it helped inform my planning. I think in the last 10 years, I've done probably 50 to 60% litigation and tax representation and 40% planning. That's the way of background. In terms of, oh great, I lost something here. I'll find it in a minute. In terms of the litigation, I think you want to start back at in a sense, start at the planning perspective, because people put together plans, and I sometimes think that they don't think about how they're going to, sorry, I just want to find my notes here, how they're going to be able to substantiate these plans when they ultimately get to court. For example, one of the points I was making to Todd was a case a few months ago involving one of the anti-avoidance provisions in the Act. And when it came to trial, tax counsel, for whatever reason, didn't call either the husband or the wife, the main beneficiaries of this plan, and didn't seem to have any documentation. And I sat there reading the case saying, well, how did you ever anticipate winning this case when you hadn't laid the groundwork back in your planning days? So I think when the planners do the planning, they have to be cognizant of some of these things like reasonableness, like main purpose, and so on. I chair a course called Tax Law for Lawyers, and it's designed generally for lawyers in the first 3 years of practice. So Todd, not being in that demographic, decided to attend anyways a couple of years ago. And I made the point to people that I think people who want to do planning should spend some time with the tax litigators so they understand the ultimate end of some of these things. And litigators should spend some time with planners so they understand what they're litigating. It's a two-way street. As I say, far too frequently planners lay out plans and have no idea how they're ever going to prove that they're within the section. For example, what's, as I said, reasonable? What's your main purpose? How do you prove purpose? And what facts should you establish in your planning? Well, what documents should you have? There's nothing worse than showing up in court and having no original documents. Sure, you've got oral evidence and people can read it, and you can reconstruct things and say, okay, here are the documents, or here's what I did, and these memoranda that I presented now help me out. But original documents are I think, are quite crucial in establishing your case. So that's the first point: is planners should be more aware of what the plan entails when it comes time to litigating if they have to defend it. Difference between, one of the major differences between tax litigation and civil litigation is that as a taxpayer, you have all the facts. In a civil litigation, you may or may not have all the facts. The defendant has a view of certain things, and a plaintiff has a view of certain things, and they may have different documents. In the tax world, it's the taxpayer who's prepared the plan, who's got the receipts, who's put things together, and it's the taxpayer that has the obligation to tell a story, but it's all within the taxpayer's ability to do so. Keep in mind that the taxpayer always has the burden of proving that it's entitled to the deduction or is not subject to tax, whatever you have. I do hear from time to time people saying, oh, the CRA will never be able to prove that. My answer is, well, that's the wrong approach. They don't have to prove anything. They just assume you didn't do something. You've got to show that you did do it. So the onus comes back to you, not on them. And that brings me to the point of the burden back to the concept of assumptions. CRA likes to make a bunch of assumptions. You'll see if you get to court, you look at their replies to the notice of appeal, they'll lay out a whole bunch of assumptions, and you have the obligation of dealing with those assumptions. Now, there are three broad approaches to the assumptions. One, you can say that the CRA didn't make that assumption, and I guess you deal with all the things that went before that, the auditor's report and so on, try to show that the CRA could have never made that assumption. That doesn't happen all that frequently. The other thing to show is that the assumption is wrong. That's where you step in there and show on the evidence. A very common example would be that someone's making a payment from a company to one of the, say, the children of the shareholder, and they're saying, well, the child never did any work at all. It should not have been entitled to this payment. And of course, you then need evidence to show that the child worked 8 hours a day, 5 days a week for all summer, something of that nature. So that's a simple example of showing that the assumption is wrong. Then the third thing is to establish the assumption, or to establish that the assumptions, even if they're right, don't lead to the conclusion that the CRA is pushing for. For example, I've got right now a case where the CRA is challenging the transfer pricing. They're making all sorts of assumptions about where directors' meetings were held and so on. And my questions on the examination for discovery will be, well, why is that relevant? And even if the assumptions are correct, they don't lead to where you want to get to. So that's the three ways generally of dealing with assumptions of CRA, but you have to figure out how you're going to deal with them. Now, in terms of, let's start with the basic level of dealing, first of all, with the audit people. My view is you don't get a long way with the audit people with fancy legal arguments. You get somewhere with the audit people with a detailed review and presentation of the facts. You're trying to find something that they didn't think about, or some fact that shows that their way they're thinking is incorrect. Obviously, the law matters, but the facts matter, I think, even more. Similarly, you go to the notice of objection stage, they're more willing to listen to your presentations on law, but again, facts are very important when you prepare a notice of objection. And then finally, if you do get to court, you're dealing with the Department of Justice, and they're much more open to legal arguments. They recognize that they have to prove their case in court, and sometimes they get cases that they know they can't possibly prove. So in those situations, they start to be more willing to listen to you. In terms of litigation, as I said, the taxpayer has the facts. So the taxpayer can succeed at trial, or potentially succeed at trial, by a meticulous preparation of the witnesses and the presentation of the story, the taxpayer story, in a clear, coherent manner. So the question, what you have to do is sit back and say, okay, what do I have to prove? What sections are involved in here, and how am I going to prove my case? What does that involve? And one of the things that may involve is an expert witness. And the question becomes, okay, how do you use your expert witness, and what are you going to lead? One of the important things with both a fact witness and a expert witness is that you want to establish credibility. You don't want to find out that your witness, what the witness is saying, isn't true. There's nothing worse than finding out that the witness make statements on the stand that aren't correct. That just shoots the witness's credibility to shreds, and very helpful. So make sure that you got the story down correct. I had an example where I was dealing with an expert, and the issue was whether what they had done in the mining was for the purpose of determining the location of a mining deposit. And the expert said to me very late in the day, almost like walking over to trial, he said, once they started the process, they did everything correctly, but I would have never started. And I said, well, he said, what do I do if they ask that question? I said, well, you got to be honest and tell them the truth. If you don't tell them the truth on that point, your rest of it's going to be useless. So fortunately for me, the cross-examinationer, the person leading cross-examination, didn't ask that relevant question until well into the examination of discovery, and the question kind of fell flat and didn't have any importance. It didn't have any weight to it. That sort of brings me to the question of how do you really cross-examine an expert witness. Remember, most cases, the expert reports will be accurate, and there are only going to be a few points where you're going to be able to challenge the expert. Mr. Justice Bowman, who's a former Chief Justice of the Tax Court of Canada, said that cross-examination should be brief, I think bloody and deadly, and it's not all those things, it's not worth doing. So you want to be able to set the stage to be able to find that the expert is either making a wrong assumption. I mean, again, he's the expert, and he can tell you that the sky is green right now, and the court's kind of going to believe him. What you really are going to go after more than anything else most of the time are the assumptions that the expert has led. If the assumptions that the expert is making aren't accurate, which we can show, can challenge him on it, or they don't, or they, you know, they aren't accurate assumptions, then his report really isn't worth very much. And sometimes expert reports are not very decisive. There are cases where the court has said, well, you know, it's very nice to have this expert report, but the expert's reports really are not all that relevant to the point in issue. And sometimes the expert's report for the other side has been quite helpful to you. I had a case not that long ago where for various reasons we didn't present our own expert's evidence, but I wanted somebody who could present the background of how hedging worked. And the other side produced an expert who did exactly what I would have done if I had an expert. And it was quite helpful to our own position. So just because somebody's an expert to the side doesn't mean that expert report won't be helpful to you. Another point in dealing with your client and the taxpayer, which I think goes in the situation all litigation, is get the bad facts out on examination in chief. Don't wait for the other side to have a go at it, because it seems to be much more devastating if the cross-examiner can kind of show that the witness was less than honest or somehow tried to hide things. Get the bad facts out. Put the best spin on you can on them, but get those facts out. Another point that we raised is never ask one too many questions. Sometimes you ask a question and the witness is absolutely devastated, and then you say, gee, I want to come back and really show the court that this guy didn't know. And of course, by that time, the witness is recovered and knows how to answer your question, and you've lost that advantage. So if you ask a devastating question, take a point that the judge has understood it, pat yourself in the back for having done it, but don't come back to that issue again. One of the other questions I was asked about CRA documents. I can remember a time when I was in trial with my principal, David Ward, and he tried to introduce a interpretation bulletin, and the tax court judge would have nothing with it to do with it. He said, no, you can't quote those things in this court. And something happened in a case called Laura West in 1985. Suddenly the Federal Court of Appeals started talking about Hansard and things in there. And all of a sudden it became open season. So I think even before the Supreme Court of Canada, you can quote virtually anything you want. What weight it will be given is really the issue. The courts have been very inconsistent with things like interpretation bulletins and so on. If the interpretation bulletin is helpful, well, you might as well quote it. Nothing's going to hurt you if you quote it. I find that the courts kind of use CRA material as adding weight. If they agree with your argument and you're presenting an interpretation bulletin, and so, right, Mr. Carr, yes, interpretation bulletins are to be given great weight. If they don't agree with you, then they say, well, Mr. Carr, you know that interpretation bulletins aren't law. So even there's a case called Widgejic that went to the Supreme Court of Canada, and the court didn't want to say that the CRA was bound by its interpretation bulletins. What they said was, well, these things are entitled to great weight. Then in Placer Dome, they said, well, you know, the minister can change his mind. So it's sort of like, where does the court want to be? It's not, if a bulletin or other document of CRA is out there and it helps you, by all means use it, but recognize it's not going to necessarily be the sword that you can run the CRA or the Department of Justice through. So that's a few points I think that I wanted to make today. And I guess if people on this out there have some questions, I'll be happy to answer them. Todd?
Oh, yes, very good, Brian. Thank you very much for those very insightful comments. And your comment about former Chief Justice Bowman, of course, was very nice as well. You had mentioned that this comment about cross-examination being concise, short, and deadly, or concise, bloody, and deadly, as Chief Justice Bowman had mentioned. Very interestingly, I actually took a course, a one-on-one course that Chief Justice Bowman had given to me. I recall a number of years ago calling him up and asking him, and his remark was, "You mean to tell me you want me to give you a one-on-one course on litigation?" And of course, feeling like I had just asked a very stupid question. And after a very long pause, Chief Justice Bowman said, "Well, the short answer is," and I thought for sure he was going to say no, but he said yes. So I had the good pleasure of hearing that directly from the horse's mouth as well, through a approximately 200-hour course on litigation that he had provided to me. And I found that to be very insightful. And a few of the things that you mentioned, Brian, as well, I can recall him, making it very, very clear about openings being fairly brief, understanding what the issue is, what law you have to support it, making sure that that the judge understands. Chief Justice Bowman and myself have done a lot together as far as dispute resolution outside of court as well. So as an example, we had many times been in meetings together with directors and different individuals within the CRA over issues that needed to be resolved from our point of view. And one of the things I recall as we were driving back from one of the tax services offices, and he said to me, Todd, he says, one way that auditors are similar to judges. And I said, what's that? He said, if they're afraid to make the wrong decision, the easiest thing to do is to say no. And I think to your point, and knowing Don as we both do, I think that he was someone who was always out for the underdog. I think that his reputation for compassion, certainly he's well known for fairness, and some of the very articulate and wise decisions he made, I think went a long way to form the tax law in Canada. And by the way, Brian had introduced himself previously and had left out many things, such as he was also the former chair of the Canadian Tax Foundation. Brian has a list of accolades that are really too long to mention, including being receiving awards for authoring books. And of course, if you Google Brian, you'll find there's no shortage of literature written by Brian. He also was awarded the Queen Elizabeth II Diamond Jubilee Medal for his service to the Canadian Tax Foundation, including a lifetime award. So I didn't want to let him escape without having some of the appropriate recognition that, of course, he deserves. And I've had the good pleasure now of working with Brian, because Brian acts as special advisory counsel to Quantum as well, for the past, I think, 3 years, if I'm not mistaken, Brian, is that correct?
Yeah, I think that's right.
Yeah, so Brian is certainly a tremendous asset to any client, and of course to our law firm as well. So thank you very much for your most insightful comments, Brian. And we'll look forward to hearing from you again in a few minutes. At this point, we'd like to move forward, and I'd like to call upon Eric Kay. Eric, would you please introduce yourself and explain to the audience what you're intending to bring to the table as far as some of your experience and some of your ideas on how you can protect individuals in the context of employment law.
Hello, everybody. My name's Eric Kay. I'm an employment lawyer with Dickinson, Wright in Toronto. I've also had the pleasure of practicing commercial litigation with Michael Miller for over 20 years. Today, I want to talk about why getting and keeping your HR house in order is more important than ever. The pandemic has exposed a lot of problems with the way people have dealt with their HR, and it's still a time when you can take steps to correct those issues moving forward. The starting point for any discussion about employment law or HR is the importance of having a written offer of employment or employment agreement, because if you don't have that, the employee is going to get not only the protection of their Employment Standards Act minimums, but they're also going to get their entitlements under the common law, which is not a good thing for employers. And it's particularly important to have a written employment agreement during times of economic stress because of the importance they have with respect to alteration of terms and conditions of employment, and especially a termination. So the first lesson that we've had during the pandemic arises out of a Court of Appeal decision called Waxdale, and it just reinforces something that's long been the case, which is just because your offer of employment or your contract is compliant when the offer is made or the contract's written, doesn't mean that it's going to stay that way for all time, and that even a future or remote possibility of breaching the Employment Standards Act is enough to adversely affect your employment agreement. And so the Waxdale decision involved a termination of employment, and the termination provision for cause was offside the Employment Standards Act. And even though the employee in question was terminated without cause, the court found that the whole termination provision had to be thrown out because the termination without cause provision was unenforceable. There was a severance provision in the employment agreement, and the court said that you can't use the severance provision to save an invalid provision. Another example is the Government of Ontario recently amended the Employment Standards Act to deal with layoff provisions. And the problem with that is that the Employment Standards Act doesn't provide a right to lay off. It just explains how the layoff has to occur and be administered procedurally. But if you don't have a written contract of employment that provides the right to lay off, then you've constructively dismissed somebody when you lay them off. And of course, we'll have hundreds of thousands of people in Ontario who have been laid off during the pandemic, who have been constructively dismissed if they want to go down that route because their employment contract typically didn't have a provision in it allowing for layoff. Lesson number 2 is that if you have a carefully written offer of employment or employment contract, that can give an employer flexibility and protection at such time. So we've talked about the right to layoff being contractual, and so that's the first important consideration that we've learned out of the pandemic, which is you've got to have a layoff provision in your employment agreement. A second important factor is the ability to reduce wages or hours or alter duties or place of employment. All of those things have to be provided for in a contract of employment, because otherwise you're left with the common law and ultimately a court determining whether, if you did one of those things, it's reasonable under the circumstances, and you don't want to leave yourself in that position. Lesson number 3 is that courts don't like employers who overreach. So although it only was released prior to the pandemic, the Supreme Court of Canada in the Uber case overturned an arbitration provision because it was found to be unconscionable. Uber wanted employees all over the world to do their employment arbitrations in Holland, and the court found that that wasn't really reasonable. So for the same reason, courts very carefully parse termination provisions, entitlement to bonus provisions on termination, because they're just not going to enforce employment provisions that they find unfair and unreasonable. They'll try and find a way around them. Lesson number 4 is that even if you have no written employment agreement currently, or the content of it is problematic because you're now offside the Employment Standards Act, or your termination provision is now in jeopardy because of the Waxdale decision, it's not too late to fix the situation, because you can always have your employees enter into what I call a continuing employment agreement. All you have to do is make sure that they receive some consideration for signing that new agreement, and the consideration has to be a tangible benefit to them. And for people who are part of American organizations, continued employment is not a tangible benefit. In Canada, the person's already employed indefinitely, and therefore just telling them they're going to keep their job isn't enough. The one thing arising out of the pandemic that we don't know the answer to yet is how the courts are going to factor that into reasonable notice of termination for people who don't have contracts of employment that limit them to their Employment Standards Act entitlements. So it'll be interesting to see whether the courts sort of ignore that factor and say everybody's got to share the pain, employees and employers, or whether they're going to say economic conditions have always been a factor in deciding what reasonable notice is, and the pandemic has an impact on economic conditions, and therefore we're going to give people more notice under the common law than we did before.
Eric, what happens if the employee doesn't want to sign a revised contract? Says, no, you didn't have COVID or pandemic clauses when I came here, and now that it's there, I don't want to. Now that we are in the pandemic, I don't want to limit myself.
Well, then it's a question of who's got the leverage in bargaining, because the employer can always give somebody working notice that if they don't sign an employment agreement or don't accept changes in their terms of employment with reasonable notice, that their employment will end. So, you know, even a long tenure employee can be told, if you don't sign this agreement in 12 months, then your employment's going to be terminated.
That's hard, harsh.
It is, but, you know, so is letting things go on, and, you know, having an employee that in a worst case scenario, under the common law, you might have to pay them 6 or 8 months pay in lieu of notice, or give them that working notice to terminate them, and you let things go on for years and years, and suddenly you really need to terminate them without cause, and now they're a 20-year employee and are entitled to something in the range of 20 months of working notice or pay in lieu, and now you've got yourself a real problem. So my experience has been that as long as the continuing employment agreement is not unreasonable, that employees will sign it, or at least will bargain for a reduced termination provision that is somewhere over employment standards, but much less than common law.
Thanks.
So unless there are any other questions, that was my contribution.
Thank you, Eric. Eric, you had mentioned that it may be necessary to offer financial consideration in a situation where there is no employment agreement currently in force. And I believe that that's quite a widespread issue. I think that there are many companies that should have but don't have employment agreements. What quantum or value would you give to such a payment in order to properly indemnify someone, or not indemnify, compensate someone for having not undertaken or not signed an employment agreement to begin with, where you're attempting to achieve an ongoing employment agreement, continuing employment agreement?
Yeah. It's a moving target, because ultimately it's in the eye of a particular judge, and some judges take a very hardline view on it and say the consideration can be anything as long as the employee acknowledges that it's sufficient. And there are other judges who have said, no, it has to be something that an objective third party would say is reasonable. And to some extent, it depends on what it is that you're asking the employee to sign on to, because if it's just really termination provisions, then that would require less consideration, in my view, than if you're also asking them to sign a non-solicitation for a senior employee, a non-competition agreement, or if it's somebody who's in a research and development position where you didn't have an assignment of intellectual property rights, getting them to give up their moral rights to inventions that they may have contributed to in the course of their employment. So the short answer is it depends, but it doesn't have to be as much as people think it is, and it can be something that at the end of the day, some people would not regard as costing themselves money. So for example, additional vacation time, where some people think it doesn't matter if somebody has more time off because that person's going to do whatever needs to be done during the time they are working. So to give them an extra week off per year or a bonus week this year for signing the agreement, you know, to the employer, that may be a nothing, but it's significant enough that it could constitute reasonable consideration for getting them to sign on. Could be a one-time bonus payment, which again, it would depend on the particular employee, because you know, $1,000 bonus to somebody who doesn't earn that much money can be significant. $1,000 bonus for somebody who makes a couple $100,000 a year isn't significant.
Eric, what advice would you give to a company who, in their mind, through no fault of their own, were affected by COVID-19 and had to terminate or lay off employees who are now seeking a solution, or rather a resolution to the problem through a claim against such a company? What advice would you give as far as, first of all, their approach and the legitimacy of a claim and the chances of success based on relying on COVID-19?
Well, if you don't have a written employment agreement that allows you to lay somebody off and you've laid them off, that's constructive dismissal. The usual solution to that one is to, if circumstances permit, offer the employee a return to work and to cap their damages. If it's a situation where you don't want them coming back to work, then it's a question of making a reasonable offer based on their tenure, taking into account whether they've done anything to find new employment. And if it's an outright termination and you don't have a written employment agreement restricting you to employment standards, then it's a question of cutting your losses and knowing that the court's going to give them reasonable notice, and not trying to play hardball by offering somebody 4 months when they clearly are going to be entitled to 8 months.
Excellent, excellent.
And
Well,
that ties back into the notion that even though employers are usually in the driver's seat, you only get yourself into trouble when you try and hardball employees, because courts don't like it. So if you know that you've got to pay common law reasonable notice, hardballing somebody at the start and not offering what you really are prepared to offer until litigation has ensued, you know, it buys you some time, but it costs you money to buy that time, your own legal fees and the extra cost of a settlement where the employee is now going to be looking for their legal costs.
So hardball is not always the best ball to play. the best game to play. So there you have it. Thank you very much, Eric. That was very interesting. And I'm sure that many in attendance either have situations or have clients in situations that may seem to be of some value with the information you've offered. I'd like to call on Mayor Makki, please. Mayor, if you would please introduce yourself to the audience and also give a summary of your message.
Yeah. Hi, everyone. I'm an associate at Quantum Business Law. I have the privilege of working with Brian Carr on most of our tax litigation matters. We have about 30 matters in front of the Tax Court of Canada, and we currently have 1 matter in front of federal courts. I also have the privilege of working with Michael Miller on our civil litigation cases. And today I'll be talking about trusts and when courts may interfere in trusts, and also touch on CPP and EI issues.
Very good, very good. Mayor, you also have the carriage of a very important responsibility in our firm. And that is
yes.
to manage a program that you were going to share with the
So
audience.
if you don't mind, I want to take control of the screen to show our participants today what we do. We have an interesting program where we give free preliminary advice on litigation matters and corporate restructuring matters. In our tax assist programs, we'll give free preliminary advice on corporate restructuring, and our litigation assist will give free preliminary advice on litigation matters. So what you do is you'll sign up to the program. Sorry about that. You can hear, I will quickly show you. So this is our website. Where you go is you click on tax assist and litigation assist, and you'll go to the bottom and you'll fill out this form. Then you'll be enrolled in our program. And what that does is once you email your question to us, and around 48 hours to 72 hours is our return time, we'll give an answer to you, free preliminary advice. So it's an interesting program. A lot of accountants and lawyers with the tax assist side take part in it all over Canada.
Well, thank you very much, Mayor. And we've had tremendous interest in the tax assist program, if I may add. Often we have accountants or lawyers that need assistance with complicated tax questions. And we like to believe we have some of the top tax people in the country in our firm, and we're certainly very happy to assist, whether it's a second opinion or whether it's some research needed on the tax side. Also, as far as the litigation side, as you can see, we have top civil litigators as well. So any way that we could help, we'd be delighted to assist with this service under the Tax Assist program. I'd like to now call upon David Yanagu to introduce yourself and also some of the highlights of where you're going to be adding advice that would be beneficial for our audience. David, please.
Yeah, I am a CBV and a CA by trade and have experience in M&A, but specifically to this discourse, I add value in loss quantification and corporate reorgs. So if there's questions surrounding those 2 items, I'm happy to answer those.
Well, thank you very much. Appreciate that, David. David, just a question for you in reference to the COVID-19, and we've talked a little bit in our last discussion about the method of reducing the value of a company in relation to the economic uncertainty. We've also focused in the past on situations where we see companies that are doing better than ever. And as far as there not being any guidelines, is there any industry-specific information that you can share or any determinants that we could use in order for a company to best understand? And I'm talking about the context of either a tax dispute with the CRA or, say, a shareholder dispute. Just curious if, because oftentimes the value of a business is of paramount importance in either context. And as far as taking a position where one could establish a reduced value, what parameters or factors do you think in today's economy should be considered?
So a couple things. Let's talk about the shareholder dispute. Oftentimes a shareholders agreement will spell out how value is broken out. So they don't rely on fair market value, but they rely on a predefined fair value method of quantification. So that is dictated by that calculation. When one thinks of COVID and its impact on business valuations, again, disparate, as you mentioned, depending on the industry. What is clear is that industries that have a heavy presence of private equity players, acquirers, those private equity players are out and buying in this COVID environment. They haven't stopped buying, which has propped up valuations. So when one thinks of tech industry, software, the software multiples have not decreased. Some actually think they've increased during the pandemic. So definitely, where there's presence or preponderance of private equity acquirers in the market, or constituents in the market, then values have remained resilient. Again, also, there's businesses that you mentioned have done very well during the pandemic. But valuation is very much a forward-looking exercise. And so if they're not going to continue to do extremely well in the future, then that's going to play into their valuation calculation.
Very good. Thank you very much, David. At this point, we'd like to have a little bit of fun. We'd like to engage our entire group in a collaborative discussion on a fictitious situation. I say fictitious, but in reality, the situation that we're going to be sharing with you is one that is not uncommon. We have a diagram that we'd like to discuss, and this is a company that Michael has aptly named Railco. And Railco is referred to that. He chose this name because this company manufactures and installs rails in the apartment building balconies. To give you a very brief synopsis of the entire situation, Railco has found itself in a lot of hot water on account of some of the issues that we've been discussing today. They've undertaken a lot of changes in their companies, and as you can see, they have done some tax planning of sorts that has resulted in problems for Railco and its shareholders that no one ever warned them could be happening. Not only have they made errors or received advice that in some ways has worked against them, but Railco is in a precarious situation. One of the issues that Railco has encountered is that they had signed a purchase order to buy material in order to install balcony rails in 100 units in a condominium. The supplier of steel, because of COVID-19, was unable to provide the rails that were necessary for Railco to honor its commitment to the developer for the purposes of construction. The developer itself was sued by the condominium because of the fact they were unable to close because of the safety regulations that required railings to be installed. Railco had to close its plant. In the process of closing its plant, because of the fact it couldn't get any materials, it suffered additional problems since it had to lay off and fire 50% of its staff. Railco is now undertaken to defend itself against various different claims. Railco's employees are suing them. Railco is attempting to sue the company that provided the materials. And of course, the developer is being sued by condominium. The entire situation had only gotten worse. Railco is made up of two individuals, Peter and John. Peter and John's father had started the company some 30 years before. The company does about $10 million a year in business. It's a substantial company. Many years ago, the founder of the company had passed away. At that time, he was married to an individual named Mary. John and Mary had separated and obtained a divorce. Prior to that, the founder of the company, George, had a will, and the will provided that the children of all of his children would share the assets equally, and the beneficiaries would be all of his children on an equal basis. Later, John remarried to Ruth, and George had not been aware of the effect that the remarriage would have on his will, but because he was content with the provision of all of the children receiving the assets equally, he's seen no reason to reestablish the will. At the time that George had done an estate freeze, and for those of you that aren't familiar with an estate freeze, that means that George, for tax planning reasons, decided to freeze the value of his shares so that he could pass the future growth up to the trust, to the Rail Trust, whereby the children and family members of his first marriage were the beneficiaries. When one does an estate freeze, it's required that there's a reasonable effort made to do a valuation on the company to determine the value of the common shares that was presently held by George. An estate freeze is effected, in this case, by George exchanging common shares that grow in value for preference shares that have a stated value, resulting in the capability to issue new common shares to the Rail Trust without the need to trigger tax, without triggering a taxable event. To make matters worse, George's shares, when he passed away, were not included in his tax return, his final tax return. The deemed disposition, which is a taxable event, was not declared to Canada Revenue Agency. Furthermore, George's estate and his second wife, Ruth, had received advice from his lawyer and accountant that since the Rail Trust already owns common shares, then to Ruth's point, they see no reason to issue new common shares from Treasury, not being aware of the effect that issuing new common shares from Treasury to the two sons, Peter and John, would have on the company. Unbeknown to them, they may have triggered a taxable event, since the Rail Trust owned 100% of the common shares, and now they only own 50%. Another problem was John and Peter, two brothers, weren't getting along very well after their father passed away. There was always issues over who should control what. John was particularly good in sales, and he decided to move all of the clients that he bought in over the last 10 years from Railco over to a new company, to new Railco. One of the questions became, from when CRA came in to do an audit, they challenged not only the fact that the father, George, had not declared the disposition of the shares, because when we die, the first person at our funeral is Her Majesty the Queen with a big bag that she wants filled with cash. Well, she couldn't get any cash, and they're coming back. One of the concerns that we had is, Brian perhaps can comment on this in a moment, would Section 160 of the Income Tax Act apply that would allow CRA to pursue whoever received that value if there's no money left in the estate in order to provide for the payment of those taxes? The other question that one might want to consider is, what liability does John have to Peter? Since Peter basically controlled the shares along with these other individuals, and it resulted in perhaps taking part of the company that he felt entitled to, not only triggering a taxable event, but should there be, from a standpoint of civil litigation, some type of equitable offset, since John and Peter both own 50% of the shares of the company? I would say that this company and this family is in a mess. At this point, I'd like to open the floor to anyone who would like to comment. Perhaps we could start off with commenting on the failure to report a deemed disposition on the final tax return of George. I would just maybe ask Brian his view of how he would best suggest this remedying the situation with CRA coming in and taking such a negative position and a negative inference.
Okay, I've unmuted myself here, Todd. Can you give me the facts just one more time? You've assumed that the CRA is already aware that you haven't filed, or are they not aware yet that you haven't recorded it?
They've just become aware of the fact that the deemed disposition was not recorded some years ago.
So you do not have an opportunity to do a voluntary disclosure. That's gone by the boards.
Exactly. They're already there, they're auditing, and voluntary disclosure is not possible. Perhaps we could amplify on that, Brian, is maybe you could explain to the audience why, once CRA is already there, they're already knocking at the door, why you cannot do a voluntary disclosure application.
Well, maybe I should just back up a little bit and explain what a voluntary disclosure application is. Generally, where you've discovered that you have made I call it significant mistake. They don't want you to start filing voluntary disclosures for a couple $100, but when there's a significant amount of money that you have not paid in taxes, and you realize that, and that may be because you were deliberately evading tax, or maybe you just found that your understanding of the law was incorrect, or your understanding of the facts was incorrect, but you've not paid your proper taxes, then you can make a voluntary disclosure. And where you do that, the CRA will definitely waive the penalties, and in some cases they may be prepared to waive some of the interest. But they have a circular on when you can make voluntary disclosure and what the criteria for it are. One of the criteria is that once they started looking at once they started doing an audit, their view is, well, they would have discovered this in any event, and therefore it ceases to be a voluntary disclosure. So we don't have the opportunity in your circumstances of making a voluntary disclosure. I think you would probably be best to disclose it at your earliest convenience, and see if you can convince them not to apply penalties.
Excellent, excellent. And just on that point, I would make also say that oftentimes we work with accountants and they realize they have these kinds of issues. And one of the challenges, of course, is that accountants are not covered under solicitor-client privilege. So one of the things that we often do, if you're an accountant, well, if you're a lawyer, you don't have to worry about it, but if you're an accountant, we will often clothe the accountant with solicitor-client privilege by bringing them into an agreement or a retainer with our firm and the client, in order to ensure that communications is protected. So one of the things that I think is important is to note that voluntary disclosure is good, but when it's combined with solicitor-client privilege, it's even better. Brian, perhaps we could just talk a little bit about what might have happened if the shares were, say, had a value of $5 million at the time, and say that they did an estate freeze based on a value of perhaps only $1 million. What would be the possible effect to the other family members?
Well, you'd have to, it may well be that, I'm presuming an estate freeze, you're filed Section 85, and as a result, it may well be that the 85-1 election will not be accepted as filed, that there'll be an automatic increase in the proceeds of disposition for the return, so that instead of having elected at 1 million, you may be deemed to have elected at 5 million.
And the effects of the Section 85 rollover would mean that typically you're deferring the capital gain. So
Yeah,
suggesting that
you may lose a lot of that deferral under, I think it's I haven't looked at it for a while, but I think it's 85 sub 1 sub E.2, which really where you conferred a benefit on somebody else, then your elected amount is not accepted. So if you dispose of, say, shares which you think of a value of 3 million, you elect at 1, but in fact the value is 5, and you transferred it to somebody who's somebody other than a holding company, then you may have a benefit conferred on them, or sorry, not so much a benefit, but you may find out that your elected amount is stepped up by a certain amount, equally like the benefit you conferred.
Thank you. Now, so in other words, failure to properly quantify the value of the shares of a company when you're doing an estate freeze. And again, we're talking about freezing, limiting, or otherwise capping the value of the shares because of the fact that no one is getting out of this planet alive. And the reality is that when we die, we have to pay taxes on the value of the shares. If properly structured, and to Brian's earlier point, tax planning it's very important to anticipate an end result that can result in tax dispute. Since our tax system is based on one of self-assessment, it's very frequent that this sort of planning might be done without proper consideration. I'd like to ask David his view of going back in time and looking at a situation perhaps 10 years ago or so, where George had passed away and the value was done and CRA has now challenging the value of the shares. David, what would you have to say as far as what kinds of issues may cause that and what would be the ultimate defense of that as well, in your view, from an evaluation point of view?
Yeah, oftentimes CRA and IRS and other tax authorities really use hindsight, use the history to their benefit, if you will, in prosecuting a tax claim against a corporation or an individual. Valuation rules stipulate that one cannot use hindsight. So someone who's doing that kind of quantification exercise has to look at assumptions that would have been made on or before the date of valuation.
And in general, the contrast between the two approaches, how often do we see CRA challenging these valuations, and what generally is the best way to defend that? I think it's safe to say that valuation is as much an art as it is a science. Yes.
Yeah, it's absolutely an art rather than a science. That's very true. Again, you just have to keep on honing back on the fact that one cannot use hindsight. And so the best defense for that is documentation of assumptions, and as granular as you can get that and supportable as you can get, that would be a benefit, obviously.
Oh, good. So you're echoing Brian's comments previously about the importance of contemporaneous documentation.
That's right.
Thank you. Now, another thing to make this worse is when the assessment came in, much to the surprise of the individuals and their accountants, there was no capital gains exemption available on the disposition of the shares. Not only was there a failure to report income by the estate, since the deemed disposition of the shares were not reported, but also there was no capital gains exemption permitted. And the reason for that is Railco was earning very good profits every year and was paying intercorporate dividends from Railco up to the holding company. And over a period of time, they started to accumulate surplus cash, well over $1 million in cash and well over $1 million of investments. According to the Income Tax Act, Section 110.6, all or substantially all of the assets of the holding company, not only the underlying company, but the anti-stacking rules in particular, has it that all or substantially all of the assets of both companies would have to be actively used in the business. And there's two cases. One I think of is Insight. The other one is Edward Riley versus the Queen. One is a Tax Court of Canada decision. One is a Supreme Court of Canada decision. Both decisions state something that I believe is a wake-up call for all of you accountants and lawyers and business owners who are accumulating cash inside of your operating company or holding company in this sort of context. It could mean that you're losing eligibility for the capital gains exemption. At this point in time, I want to call on Mayor Makki because I'd like to change gears, because there happens to be a matrimonial claim against the a beneficiary of the real trust on account of a marriage breakdown. And one concern is, as a beneficiary of a trust, what would the court's view be, since this individual was only a beneficiary and had no direct ownership in a fully discretionary trust? I'd like to call upon Mayor Makki to comment on the likelihood that the court would make an order to break a trust and how they would potentially look at these assets since there's no direct ownership, albeit that's only an argument, not to say that the courts would take a position that they would disregard those assets, but what would be the likelihood of a trust being broken? Mayor Makki?
Yeah, so generally speaking, trusts play an important role in our Western civil society. Courts are reluctant to break trusts, and unless the estate trustee is acting in malfeasance or bad faith. And this goes back to a 19th century case, Gisborne versus Gisborne. It's a House of Lords case where the estate trustee was breaching his fiduciary duties. So in that context, we know that courts will interfere in a discretionary family trust. In more modern times, courts have intervened in the family law context, just like our hypothetical scenario here, where spouses are separating. As you know, family courts are courts of equity. They don't look at contracts as much. They want to see an equitable distribution of the estate. So the issue becomes, does the discretionary family trust form part of the net family property, which will be equalized when the spouses are separating? I think the starting point for that is to look at the deed itself and to see to what extent does the document demonstrate that the beneficiary controls the trustees either directly or indirectly. And the courts really emphasize this control, and if the beneficiary controls the trustee either directly or indirectly. And courts have been sort of all over the map on this issue. And part of the problem is subsection 4.1 of the Family Law Act, the way it defines property. It gives a lot of rights to the beneficiaries in disposition of the trustee and disposition of the assets. So it's left courts coming in diverging views on this. So we'll look at two quick cases of Court of Appeal cases. Same court came to different interpretations of this. The first one is a 2016 case. It's Tremblay versus Tremblay. In this case, the wife sought to equalize the assets held by the family trust, which the husband had an interest. The husband's father had set up a complex corporate structure, and the husband was both a beneficiary and trustee of the trust. Justice Phillips found that the husband did not own the property as a beneficiary, but his inquiry didn't stop. He further found that none of the transactions were arm's length, and while the trustees were the husband and the parents, the husband had the sole ability to appoint more trustees, which meant he could always access the funds. The degree of control, which we'll see in other cases is the defining factor, meant that the interest as a beneficiary was a certainty. As a result, he was obliged to include the property in the trust as a net family property. Same court in Spencer versus Riseborough came to a different conclusion. In this case, the wife's mother bought 4 properties, one for each of her children and their families to live in. The properties were held by a trust, and the beneficiaries of the trust were all 4 of the mother's children. When the couple separated, the husband sought to have their home held within the trust, including the wife's net family property, and equalized. The court went on to state that even though the wife was both a trustee and a beneficiary of the trust, in this case, it did not mean that the wife had control over the trust. So what we get out of these cases is sometimes wealthy spouses, and just like this scenario we have here, wealthy spouses want to control what happens to their property when they're separating. So when they're setting up this structure, they want to exert control. The paradox in that is the more control they exert when they're setting up the structure is you'll see that it defeats the whole entire purpose of why they're setting up the structure.
Thank you very much, Mayor. That comments were excellent. We have 6 minutes left. I'd like to invite Michael Miller to please give a brief commentary on the implications of civil litigation, of Brailleco, their issues involving the failure to perform of their supplier, and the other incidental issues that would stem from that litigation. Michael, please.
Thanks, Todd. Firstly, this diagram shows millions of dollars in new spending on lawyers and accountants. So they can all get very excited about this. everybody will be suing everybody and for a long time. So I just wanted to point that out. Realco took, new Realco took basically all the assets of Realco when John left Peter. So there's a lawsuit there saying that they stole the confidential information and client list and system of Realco when new Realco was set up. So there's a claim for that Realco would bring against new Realco. Everyone would be chasing Holdco because that's where a lot of assets are, and they would be looking for that. Everyone would like to know why when the older brothers split and walked away, why those shares just stayed on the books of the company. So that's a problem that is not that unheard of, that minute books are not brought up to date unless there's an event happening. And accountants and lawyers who are relying on the minute books, I believe, have an obligation to do the appropriate searches and to make sure they've investigated where the shares are and who has them, and not just rely on a story told by a family member or one of the partners of the company. So those are the things that Eric is suing for, is involved in lawsuits for employment, and Mahyar is involved with rich spouses that are separating. And Brian, you and Todd are involved because of the trust and the what's gone on here by accountants up until now in this diagram have been pretty sloppy. So you guys are dealing with CRA and with others who are trying to be part of those assets. So that's sort of everybody's suing everybody.
Thank you very much. I noticed that we're about to reach our 2:30 stop point. And of course, we always finish on time. That's our commitment. In closing, I would like to say that we see many situations where there is either no tax planning at all, but lots of complexity, or there's tax planning with very severe mistakes. These kinds of situations we see far more often than we like to. Not only is there liability for the entrepreneurs who trusted their advisors, but there's also liability for accountants and lawyers who are giving advice that may cause liability down the road. As an example, the Peter and John situation, purely that would have been a disposition of the shares of Real Trust, and that would have been a taxable event. Most of the moving clients are an asset. I've had so many discussions with accountants who said, but those aren't assets, they're just clients. They can make a decision to go anywhere they want. Well, that doesn't hold water, since goodwill, I don't think anyone would argue, is certainly value. The company's capability to make future income based on its reputation, based on the name that it's earned in the industry, based on its intellectual property, all of that is represented by clients. In most companies, the clients are often the most valuable of assets. To look at clients as not being assets because they have the choice to go where they want is faulty thinking. So we'd suggest that that not be considered. We have 1 minute left, and I'd just like to give Eric an opportunity to give a 1 minute synopsis on the employment issues in the context of here that he's already covered. Eric?
You've caught me flat-footed because I was I was actually on a call with a client.
Oh, no problem. No problem. So I would say that you've already covered all of the issues anyway, as far as what are the reasons that might be problematic for companies that don't have employment agreements. So I would say that all of the things you said were very artfully crafted and apply nicely to this illustration. Having said that, I would like to thank all of the members of our expert panel, Brian, David, Mayor, Michael, and Eric for today's presentation. And most of all, we'd like to thank all of you. Please take advantage of our tax assist program and our litigation assistance program for assistance with any litigation or tax corporate law issue that we can be of assistance with. Our group is committed to education across Canada. And also we're committed to helping to support you in your practices so that you can provide more value to your clients. We thank you very much, and we wish everyone a very pleasant day.
Thank you.
Thank you.
Thank you.